Hello, YouTube. I'm Vince White. I'm an employment attorney on this channel. We answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. Now, this isn't necessarily a question that was posted on one of our videos. It was brought up a couple times during a recent live stream I did. And one person in particular kept asking, hey, do you think my case is worth $1 million? And it was, I believe, a workplace discrimination case. Could have been a workplace sexual harassment case. I don't recall. But the answer is largely the same, right? And listen, there's a lot of attorneys on this platform. I think Brannigan Robertson has a video to this effect. What does $1 million employment case look like? And my answer is going to be a little bit different than Brannigan's. Hate disagreeing with Brannigan, although I often do, just on small things. Listen. Great guy, seems to be making great content, seems to be helping people. Handsome fella, right? Handsome man, right? But that being said, I did find his video as to what makes $1 million employment case to be a little sensational, perhaps, just a little extra, maybe. So here's the answer that I'm going to give you. $1 million employment law case is a case that has significant economic damages, egregious facts that lead you to believe and support a large emotional damages component, and probably, very likely, some kind of retaliation claim, which gives rise to punitive damages. So you have all three classes of damages. You have your economic damages, you have your emotional damages, and you have your punitive damages. Now, right off the bat, if you're trying to settle a case, take those punitive damages and set them aside. They're going to help you settle the case, but they're not going to be part of the valuation most of the time. Now, then you're just looking at your economic damages. Is your client a high earner? Did your client experience a large loss of wages, right? That's how we substantiate economic damages. And you extrapolate that forward. How long will it take your client to mitigate, to find a new comparable job that pays similarly and has the same job prospects and all of these things, right? Hopefully you can get a couple of years that way. You add all that up, that's your economic damages. You take your emotional damages, you add that up. Listen, there's some caps here and there, but you hopefully have some state and local laws that have no caps or better caps, right? And you figure out what do I think I can really substantiate in terms of the emotional damages? Is my client treating with a mental health professional? Is my client, when they treat with their mental health professional, talking primarily about the events in the workplace, this workplace discrimination, this workplace sexual harassment? Is that what they're talking about? Are they talking about how mommy didn't love them 35 years ago, right? Because one of those is worth money, and one of them probably isn't, unless you're suing your mom. I don't know. But I suspect, if you're not talking about your job when you go to your mental health professional, that mental health professional may not be the most effective witness to substantiate emotional damages verdicts in your case, right? So you got your economic damages for X amount of dollars. Whatever emotional damages you think you can really prove for Y amount of dollars, X and Y, right? We add the X, which is the combined value of all the economic damages, and we add the Y, we add them together, we get a result. Z amount of money, right? And then we say, okay, we can't assign a probability to winning a case. That wouldn't be ethical. But in our heart of hearts, just for the purpose of hedging risk, if we ran this trial 10 times, how many times do we think we win? 7 out of 10? Okay. So we have Z damages. Let's just call it, I don't know, $2 million. And we think we win 70% of the time. Well, embarrassingly, I don't know what 70% of $2 million is, because I'm an attorney, not a talented mathematician. However, before $1.4 million. So if you think you win that case, $1.4 million, an intelligent strategy might be to hedge for risk. Case is worth potentially $2 million. That's what you could hope to win at trial, you think. It's probably your best calculation of your upside. You think you win it 7 out of 10 times if you run the case 10 times, but you acknowledge you only get to run it once, and that's a lot of risk. So you might hedge for risk, and you might say, listen, my settlement figure is 1.4 million. Great, we just calculated $1 million case. That's a $1 million settlement case, right? Now, if you're not trying to settle the case, well, that's even potentially more upside, right? Because if you're willing to embrace all that risk, and you have an attorney who's ready to do so for you as well, then you can take it to trial and you can try to win even more, right? You don't have to hedge for risk if you're not settling. You're not hedging for risk at all. You're embracing risk. So instead of hedging and going after that $1.4 million, you're just rolling the dice, taking that trial, seeing what you can win, hoping you win $2 million or more, right? You certainly could. And listen, if you win more than you think the law really provides, more than the law would allow you to win, there's a good chance that judge will knock you down. But listen, that's a high-class problem to have. Winning too much and then getting knocked down by a judge, it's a lot better than winning too little or losing, right? So that's $1 million case. That's what $1 million case in this field looks like. And I know that seems a little oversimplified, a little reductive, but that is actually how you would determine if a case is $1 million case. What are the economic damages? What do they add up to? What do we think we can get in economic damages, right? What are the emotional damages? What do we think we can substantiate emotional damages, right? If you're going to settle, is the number of that combined figure high enough that even when you hedge for risk, that settlement figure is still over 7 figures? Because that's what a 7-figure case looks like in this field. Now, remember, if you're going to trial, you get to add those punitive damages back in. Defense counsel generally won't settle a case based on punitive damages because they're highly speculative, right? There's no real way to know if you're going to win punitive damages, and there's no way to know what a jury or a judge or an arbitrator might assign you in punitive damages. Those are ineffable, unknowable, beyond what we can guess, right? Because what we're really saying is like, hey, somebody sees a trial that we've never seen, and that somebody happens to be 6 people or more that we've never met. What number would they assign to the punitive damages for this retaliation claim? And if you pretend that you know what that number is, you're an asshole, because you don't. You haven't seen the trial. You don't know how it's going to go. You haven't met the people. You haven't selected the jury yet. Like, you just don't know. That's why they won't settle, generally speaking, purely on a punitive damages component, right? Now, that being said, let's not forget that even though they won't assign a dollar value to the punitive damages, that punitive damages component is hanging over their head like a huge guillotine, and they're terrified of it. So while they might not want to assign a dollar value to it, and they might refuse to do that during negotiations, they will also be sweating bullets when negotiating the economic and emotional damages components of the case, and you can probably get a lot more for the economic and the emotional damage component of the case because you don't have to hedge for your risk quite as much because defense counsel and your defendant are terrified of that punitive damages component, right? So you might not have to hedge as hard. Now, we spent this time showing what a 7-figure case looks like in this field. Let's go a little further. What would not be a 7-figure case? Let's say you got a person who makes $40,000 a year. $40,000 a year, and you think they're going to be unemployed for 3 years trying to find comparable employment. Economic damage is $120,000. Super simple, right? And the case is pretty egregious. They've been through a lot, so you figure, okay, $200,000 in emotionals. They're treating, but they didn't treat that much. And when they spoke with their mental health professional, they spoke about a lot of things, not just the case, right? And it doesn't just have to be the case, but maybe it was mommy 60% of the time, the job 20% of the time, and their spouse cheating on them the other 20%. All things that you might want to talk to a mental health professional about. But in the course of your case, not the most valuable things to talk to a mental health professional about, right? And I'm not telling you what you should and should not treat about, but I am telling you that when you look at this, you have to say, okay, so that's not ideal. That's not the best way to substantiate a large emotional damages verdict. So we're going to call it $200,000. Okay. So we think our upside for the economic and emotional damages combined, probably about $320,000. Not nothing. It's a real solid case. You've been wronged and we need to make you whole. But it's not a 7-figure case. It's just not. We can do it another way. Let's say you have a solidly 7-figure case. It's worth $1 million. We calculate the economic damage and the emotional damage, and we think the combined value is $1 million, right? But secretly, in the privacy of our office, when having a frank settlement discussion with our client, we say, hey, the thing about you is that you were horribly wronged and really bad things happened to you. But you have a really hard time talking about it. And when you do talk about it, because I think you get nervous, sometimes you say things that aren't true. You're not lying. You're just making mistakes. But that is tough. That's tough. That's problematic. Because if we go to trial, it's going to sound like you're lying, even though the lies wouldn't even help you. It's just you can't keep your story straight, right? Or we'll go another way. Hey, when people question you about your case, how you flip out and try to fight them, like fist fight them, that's not going to go well at trial. And we've been working on that for 6 months, and you're still taking swings. So, we should not go to trial. I think if we run this trial 10 times, I think we win 5 out of 10. Best case. And that's basically just if we catch you on a day when we can keep you calm, we can keep your story straight, right? So yeah, you got $1 million in damages, but if you're hedging for risk and you want to settle your case, and you might want to settle a case and you only win about half the time. That's a lot of risk to embrace. You might not. Listen, I don't know what your risk tolerance is. Maybe you're like, I win at half the time. Let's go. Mug half full. Roll the dice, right? Or maybe you say, wait, I only went half the time, and if I win it, theoretically I might win like $1 million. But if I don't, if I just take this settlement, I can get $500,000. You might say the settlement's a good idea. You very well might, right? So that's a case that's, worth $1 million potentially if you can embrace the risk of trial. But realistically, you may not want to. It may not be a good idea. I'm not trying to pressure you to settle your case. I'm just saying you got to be realistic. If you're not really ready for trial, if you're not really the kind of human being who might be able to go out there and share their story and go through this difficult process of litigation, then you might find hedging for risk and taking less than $1 million is a good idea. Now, we're not going to tell opposing counsel that. We're going to tell opposing counsel you want to go to trial tomorrow. You're the best witness I've ever done seen. You're the sun, the moon, and stars of litigation. You are as good as it can be. You are the most compelling witness I've ever known. Between you and me, nah. All bullshit. You suck. This is not your job. This is not what you do for a living. You haven't done this in your life. It's not something you're practiced at. It shouldn't be something you're good at. And that's okay. But we do need to be realistic. Hey, this is not going well. And you do have 7 figures of damages. And I do want to put up a result for you. But I got to tell you, there's $500,000 over here that they're begging to give you. And secretly, between you and me, it might be the smart money, right? So that's a 7-figure case that gets hedged for risk out of 7 figures. That happens too. That's a reality. There's a lot of other components that go into this, right? The court of public opinion. Is your case already out in the public? Are there famous people involved in your case? Is there leverage to be held from the notoriety, from the publicity on the case, right? And you're not blackmailing anyone, but like if the case goes forward, it's out in the press. That's not your fault. You have the right to pursue your case. And so incidentally, there's some form of leverage created that way that you're not, at fault for. You didn't create that. You're not trying to do something to embarrass your employer. You're just pursuing your rights. And it happens, incidentally, that harms your employer's bottom line. Harms their reputation. That can certainly increase the value of your case in settlement. Significantly at times, right? You might find different jurisdictions. But I believe Brannigan Robertson brings most of his cases, to my knowledge, in California. Cases tend to be worth a little bit more in California than in most of the country. And by a little bit more, I kind of mean a lot of bit more, right? Different jury pool, different laws, the number of advantages. California's a hell of a place to litigate a workplace discrimination or workplace sexual harassment claim. It's just what it is. It's the reality, right? So, listen, there's lots of small factors that will adjust the valuation up, down, add risk, reduce risk, right? These are all the attorney you hire. Are they running around adding value and reducing risk every day, or are they asleep at the wheel? Really changes the calculation, right? Really changes your risk calculus, really changes what you might hope to walk away with in settlement, really changes what you might hope to walk away with in trial, right? So my point is, you can't just say, I've got a pretty good sexual harassment case. Do you think it's worth $1 million? It's an involved, extensive thought process where you wrestle with hard truths and hard data, calculate the damages as per the law, make fully informed decisions about what you feel you might win if you win, and how likely you feel it is that you win. And that is how you arrive at a valuation, both for settlement or what you might hope to win at trial. Two different numbers, right? And then you make an informed decision. Do I have a 7-figure case? Do I have $1 million case? Do I have a case valued in the tens of millions? Unlikely. I think the record in our industry might be $28 million. To the best of my knowledge, that's the highest I'm aware of at this time. And then you know what you've got, right? And I want you to know what you've got, because then you can make informed decisions and you can be made whole, and you have the ability to prosecute this case against your employer and fight and claw your way back to where you were before someone attacked you on the basis of your identity, or they sexually harassed you, or whatever it is they did to you, right? I want that for you. But I do think sometimes we have to add a little dose of reality. Just a little bit, right? There's a fair number of people with $120,000 cases demanding 30, 40, 50, $800 million. Generally speaking, it does not go well. It doesn't. It's just a reality, right? And so I'm making this video because I think it helps folks to kind of see what you should be thinking about and how that thought process can inform your decision making in a way that lets you make the best decision for you. And in this moment, I'm making this video. I'm not your attorney. So you know I'm not trying to sell your case out. I'm not trying to get you to take a junk settlement so I can be done with it. It's just a video from a guy on the internet who does this for a living, who's saying, hey, here's some things to think about. You may want to be realistic. You may not want to make up silly town numbers. And that's, frankly, the best advice you're going to get on the internet. You might want to be fully informed. You might want to go through the nitty-gritty and have a detail-oriented process for how you value a case. And once you are fully informed and you've been realistic with yourself, you should decide what you might be willing to take in settlement, and if you're willing to embrace the risk of trial. And what are the numbers, the valuations that you attach to either of those as best you can. These numbers are not definite. These numbers are not absolute. These numbers have as much art as science to them. There's a lot of judgment. There's a lot of judgment. And that's challenging for the plaintiff here, because it's hard to use judgment in a field where maybe you don't have many repetitions. This might be your first case ever. And you might be dealing with an attorney who's had 500, 5,000, 500, probably not 500,000 cases, but 50,000 cases. Possible in a long career, I would say. Maybe. I'm just saying, you're dealing with a lot of people who have a lot more repetitions in the field than you do. So sometimes you're stuck dealing with someone who's going to say, yeah, listen, I think it's worth this much. And you're going to say, why? And they're going to say, well, because this is how I feel about this particular data point in your case. I think it's really strong, but I think the way you testify is kind of challenging. and we've been going through testimony prep and deposition prep, and you're not listening great, so that concerns me. And so the totality of the circumstances, this is what I feel. You don't have to agree. It's your life. You're the one who was harmed. You don't have to agree. But I would recommend you listen. Because theoretically, you hired that person because you trust them to do right by you. Probably they're working, at least primarily, on a contingency. So they should very much want to put up a result for you, a win for you, right? Every dollar they win you puts some money in their pocket. So they're self-interested and they want a good result. And hopefully they actually care about you. And, it might be a situation where you should consider listening a little bit. Just saying. Anyways, if this was helpful, like, subscribe, comment down below. Share our channel so it can grow. Take care.